is the one that put the peanut butter in the jar, the one that made the peanut butter. If anybody was negligent, it must have been the manufacturer. But now we have to look at that first element of res ipsa. Can we say that a whole peanut is not likely to get into peanut butter without negligence, so that we can infer there was negligence? Well, you can argue about that, I suppose, one way or the other, but I will tell you what most courts have said. Most courts have said that where food products are involved, if the thing found in the product is associated with the product, then there are lots of ways it could get in there without negligence, and res ipsa should not apply. In other words, if I find a cherry pit in the cherry pie, if I find a walnut shell in the walnut cookies, if I find a whole peanut in the peanut butter, res ipsa should not be applied, because those items that were found in the foods really are associated with the foods, maybe even belong in the foods in a way. Anyway, there's lots of ways they can get in there without negligence, and so it's not fair to infer negligence from their presence. Res ipsa should not apply. On the other hand, if the thing found in the food product is not normally associated with that food, for example, I find a walnut shell in the cherry pie, or I find a cherry pit in the clam chowder, or I find a clam shell in the peanut butter, the chances are that it could not have gotten there unless somebody was negligent, and res ipsa loquitur should apply. In this case, we're talking about peanuts in the peanut butter, and it's real unlikely that any court would apply res ipsa loquitur to hold the manufacturer liable for negligence. Well, if we can't use circumstantial evidence to establish negligence by the manufacturer, and if we don't know what the manufacturer did, so we can't prove it was unreasonable, we're not going to be able to make out a negligence case against the manufacturer. Does the plaintiff lose? Not necessarily, because there's another theory. And the other theory is something that the law of torts borrowed from the law of contracts. It's the warranty theory, which Dean Prosser called the bastard child of the illicit union of the law of torts with the law of contracts. He had a way with words, Dean Prosser did. The warranty theory is based on a principle of contract that says when you make a promise and you don't keep the promise, you're liable without regard to fault. Without regard to fault. We're going to come back to that phrase in a little while. When you make a promise concerning the quality or nature of a product, that promise has a special name. The name is warranty. It's just a special kind of promise, that's all. Anyway, we call this theory breach of warranty, the broken promise theory. Warranties come in two varieties: express warranties and implied warranties. Express means stated in words or a substitute for words. Implied means not stated in words, but something that the reasonable person would gather by observing the transaction involved. Let's take them one at a time. An express warranty is a promise, an assertion of fact that's stated in words or a substitute for words. And the courts have been somewhat liberal about construing words that are used in connection with products, so that it's generally understood that a photograph depicting a product makes statements about the product. Sometimes a photograph coupled with a slogan makes statements about a product. There was a case in which an automobile company marketed a certain pickup truck by showing on TV a film of that truck bouncing and jouncing over some rough terrain, while a voice in the background sang, "Fun truckin', fun truckin'." I think it was Ford. In any event, the plaintiff bought one of those trucks and was injured when the truck fell apart while it was being driven over rough terrain. And the plaintiff sued the defendant and said, "You promised me this truck could stand up to rough terrain, and it didn't." And the defendant said, "Hey, we never promised anything about rough terrain." And the court said that the film that showed that truck bouncing over rough terrain, coupled with the phrase "fun truckin', was an assertion that the truck could safely be used on rough terrain. And if it, in fact, could not be safely used on rough terrain, the warranty was breached, the promise was broken, and the defendant was liable without regard to fault. Without regard to fault. You may read a case about a car manufacturer that said that the glass in its automobile, the windshield in its automobile was shatterproof. And the plaintiff bought one of those cars and was involved in an accident when the windshield shattered and the plaintiff was injured by pieces of glass. And the plaintiff sued the defendant and said, the windshield turned out not to be shatterproof, pay me. And the defendant said, hey, we used the best windshield that money could buy. No windshield is truly shatterproof. The one we used was as close to shatterproof as we can get. It's not our fault that it shattered. And the court said, express warranties have nothing to do with fault. You said it wouldn't shatter, it did shatter, you pay. That was a breach of express warranty. Back to our peanut butter case. The label said smooth peanut butter. First of all, is that an assertion of fact about the product? If it is an assertion of fact, what fact does it assert? Once we decide what fact it asserts, then we can decide whether the assertion, the warranty, was breached, whether the promise was broken. Now, if I were representing a plaintiff in this case, I would say that peanut butter usually comes in two varieties, smooth and chunky. Chunky peanut butter is known to have bits of whole peanut in it, but smooth peanut butter doesn't have any whole peanuts in it. And so the phrase smooth peanut butter on the label is an assertion of fact. It asserts, in fact, that there will be no whole peanuts in this product. The presence of a whole peanut in the product was a breach of that express warranty, and the defendant ought to pay. On the other hand, if I were representing the defendant, my argument would be the word smooth is simply an expression of opinion which talks about how easily this product can be spread on a cracker or spread on bread, or how nice it'll feel going down the throat when it's swallowed. Smooth is an expression of opinion rather than an assertion of fact. Therefore, it does not result in a warranty. There has been no breach of express warranty, and I'm not liable to the plaintiff. Which argument you like better? I don't really care. I don't care what conclusion you come to. I don't think your professor is going to care what conclusion you come to. What matters is the argument you make in support of that conclusion. Because. Try to keep track of that because. Now, you're studying contracts now, or you have studied contracts, or you will study contracts, and when you do, or when you have, you learned that ordinarily a contract is only enforceable between the parties to the contract. Some question might arise as to whether the manufacturer who put the label smooth peanut butter on the jar, or the grocer who sold the jar with the label smooth peanut butter on it, had entered into a contract directly with the plaintiff. Hey, let's make it more interesting in this case and say that the peanut butter was actually purchased by the plaintiff's husband. And the plaintiff came home from work and found the peanut butter in the cabinet. Her husband had purchased it. She was eating it with a spoon when she choked. Nobody really made a contract with her. The manufacturer didn't know her or her husband. The grocer might have made a deal with the husband. I'll sell you this peanut butter, you give me this money. But nobody made a deal with the wife. Doesn't that mean that she cannot collect under a contract theory? Well, if this were a contract case, if she was seeking damages for commercial damages for breach of contract, yeah, it might preclude her from recovering. But most jurisdictions hold that in a product liability case, the warranty flows from whoever made it to whoever relied on it. The warranty in this case, if it was a warranty, the warranty in this case was made by the manufacturer who put the label on the jar and by the grocer who delivered the product with the label on the jar. So the warranty comes from them, and the warranty goes to whoever relied on it. So if Ms. Plaintiff relied on it when she dipped into the jar with a spoon to eat the peanut butter, then the warranty flows to her, and she is entitled to enforce the warranty by suing for damages for breach of warranty. That's the express warranty theory. But many